This video is about planning for financial and legal affairs in case of incapacity, for end of life, and other support needs. My name is Joanne Taylor. I'm the Executive Director and Registrar of Nidus. This presentation is basic information. It is not legal advice. We have other videos and more resources to cover various aspects of personal planning. Nidus is a BC-wide nonprofit charitable organization established in 1995 by other community groups. Those groups have been involved in a grassroots law reform of adult guardianship. Out of that law reform came the Representation Agreement Act and healthcare consent legislation. Nidus was set up to be a resource on the new legislation and to provide education and assistance. We also offer a registry service to help communicate important information and documents. Nidus is Latin for nest, a symbol of support and safety. And our safety and security is in being informed. This could be a short 2-minute video if there was more general understanding of the topic. But there has been no systematic education for professionals in any sector or community groups or the public about the concept of personal planning or the Representation Agreement Act. Misunderstandings and lack of knowledge leads to poor practice in some cases and hypothetical problems. And unlike with making a will, where we turn ourselves over to the legal experts to make sure that our document gives the necessary authorities, it hasn't been the practice to have to explain that document to those we appointed, as it'll be used after our death, and institutions that they have to deal with will point them in the right direction. But what we're talking about is making documents and arrangements for while you're alive. And it affects your quality of life. And so it is important to understand what the documents cover and to be able to explain that to the people you've named and others as well, because the people you named will have to know what it means when they go to use it with third parties to maintain and enhance your quality of life. So there is going to be some time and effort in learning more about this so you can help yourself and others. And what do we mean by personal planning? Well, it's different from estate planning. Estate planning is about making arrangements for after death. Personal planning is about making arrangements for while you are alive. And personal planning covers 4 life areas: health, personal, legal, and financial. We don't live our life in separate compartments, but there are laws, policies, institutions specific to those areas. And this chart shows some of the tasks or activities that might fall under legal and financial, which is the focus of this video. It's important to plan for all life areas because they are related, and your financial resources are going to affect decisions about health and personal care services, whether you're eligible, whether you can get a subsidy. So it's important to have a plan for all of those areas, and we're looking at legal financial in particular. Because of the law reform, we have 2 paths for personal planning in British Columbia. The future path is the traditional path for adults who understand the nature and effect of their planning documents at the time they are making them. The Need Help Today path is for adults whose capability to understand the nature and effect may be in question at the time they're making their legal planning documents. This path may apply to adults with a disability from birth or childhood, or adults with advanced dementia, or who've just had a very serious stroke. There are different legal documents or tools depending on the path. Again, we're looking at the legal financial areas, and there's 2 documents on the future path that can cover some legal financial areas, and a different document for the need help today path. We're going to look first of all at the future path. And we're going to take a couple of examples. John is relatively healthy, although as a caregiver, we know he has some extra stress. But something could happen to John, which would affect him as well as the person he is supporting. Cynthia is scheduled for major surgery, and there's always risks and benefits, but how does she prepare? And in both cases, they're thinking about who will pay the bills, who could access information from Canada Revenue if necessary. Maybe they have to change the mailing address, various things that could fall under financial and legal affairs. So the first document we're going to look at is the enduring power of attorney on the future path. An enduring power of attorney is British Columbia's most comprehensive planning document for financial and legal affairs. And just to note that a power of attorney is not the same as an enduring power of attorney. It's important to use the correct terminology. A power of attorney ends if you become mentally incapable, whereas the authority given by an enduring power of attorney can be in effect while you're capable and endures if you become incapable. We have a fact sheet and a video about the differences between power of attorney and enduring power of attorney if you want to know more. You must be 19 years or older to make an enduring power of attorney. 19 is the age of adulthood in British Columbia. You must understand 6 items in order to be considered capable of making an enduring power of attorney, and these are spelled out in the Power of Attorney Act. For example, you have to understand the property you have, and that is not just real estate, but personal property. Maybe you have expensive jewelry, artwork, as well as your money in the bank account, investments. So you have to understand what you own and the approximate value. You have to understand any obligations you have to others, such as a spouse, children. You have to understand that the person you appoint in the enduring power of attorney will be able to do anything on your behalf with respect to financial affairs that you could do when capable. Nidus recommends that you consult with a legal professional to make an enduring power of attorney, as they have access to the knowledge about that document. And this is especially important for any land title purposes. Nidus has information to help you prepare for your meeting with the legal professional, a checklist of things to take with you for that meeting, as well as some of the options that you have that you can think about and discuss with the legal professional. So it adds value to the time and money you spend. We have a guide with details of making and registering an enduring power of attorney, and we also have a fact sheet that shows some of the specific authorities that you could include in the document. So we've looked at the enduring power of attorney, which is one of the legal documents on the future path to cover legal financial affairs, the most comprehensive document. There is another document, the representation agreement. Section 7 can cover some financial and legal affairs, not as much. And we're going to look at that next. So it is an option for some people on the future path, but the Representation Agreement Section 7 with routine financial legal affairs authorities does not cover as much as the enduring power of attorney, as I mentioned. Like the enduring power of attorney, you must be 19 years or older to make an RA7 F&L, as we call it. The authority for routine management of financial affairs under the Representation Agreement Section 7 is defined in the law, in the regulations. So you can look at a list of what is covered and not covered. The Representation Agreement Section 7 with authority for routine finances requires an extra safeguard unless the representative is the adult spouse, your spouse. So if the representative is not the spouse, or you're going to name an alternate, you satisfy the extra safeguard requirement by naming someone in the role of monitor, or naming at least 2 representatives who must act together jointly for finances, and you'd need special wording for that. Nidus has forms for the RA7 F&L. No legal professional is required. It is important to make the document you need. And we have information to show what is covered under the enduring power of attorney versus the RA7 F&L. We have a comparison chart, and you can also look at that definition of routine management of financial affairs. We also have information on some alert topics. When people are thinking of arrangements for financial legal affairs. We have information on the perils of joint ownership with someone other than your spouse, something you need to be very cautious about. We have information on bank power of attorney, which is an old practice but not sufficient for personal planning. And we have a fact sheet on adult guardianship, which is also called comitationship in British Columbia, when you do not have a sufficient plan for finances in place. And that's why we say it's very important to make the document that you need while you can. You will find information on our website for people on the future path about the enduring power of attorney, the RA7 F&L. Click on the middle photo, middle heading at the website on the home page to find more information and links to documents. What if mental capability is in question? We're now going to look at the Help for Today path. And we have a couple of examples again. We have Mary and Albert. Mary's dementia has progressed. Albert had a serious stroke. We don't know if the brain damage is permanent. He made a will, but he's not dead. Mary and Albert do not meet the capability requirements for making an enduring power of attorney. How can they get help from those who care and know about them? They can make a Representation Agreement Section 7. That's the legal document for the Need Help Today path. And this chart shows that it covers aspects of all 4 life areas. We're talking in this video about the routine financial and legal affairs, which are covered under the Representation Agreement Section 7. The Representation Agreement Section 7 has a different view of capability than other laws or documents like the enduring power of attorney. For the RA7, there is no specific criteria that everyone has to meet. Even if a doctor says an adult is mentally incompetent, this does not prevent them from making a representation agreement, Section 7. They don't have to be assessed to make it. But if a doctor says that Mary or Albert are not competent, that would be a green light to help them make a representation agreement, Section 7, so they can get help from people who know and care about them. The RA7 is a legal alternative to guardianship and also used by adults with a disability from birth or childhood who may need assistance with decision-making and managing their affairs on an ongoing basis. For example, youth with disabilities who are transitioning to adulthood, older adults with disabilities who have aging parents and are going to need assistance when those parents die or if they become incapable. So for people on the Need Help Today path, you will click the first photo or heading for adults with a disability from birth or childhood. To help someone like Mary or Albert who don't meet the capability requirements of the future path now, you can click on the third photo or heading to find information and forms for the representation agreement, Section 7. Other information and resources. It's important to know what's not covered. No one, including an attorney in an enduring power of attorney or a representative in a representation agreement, Section 7, can have authority on your behalf to make your will, change your will, or use your credit card. What if you don't have anything in place for financial and legal affairs? Well, in that case, you are vulnerable to adult guardianship, which is also referred to in British Columbia as comitationship. And under guardianship or comitationship, adults lose their rights, sometimes called civil death. You become a non-person, and your financial and legal affairs are taken over by someone who is appointed by a judge after a court hearing. So a family member may have to go to court, or a spouse even have to go to court to get authority to help you. Or in some cases, the public guardian and trustee, a government official, will take over your financial and legal affairs if there is no plan in place. Now, making a plan is only one part of the process. And we have information on all aspects, and we want to put a bit of a spotlight or draw some attention to this. So when you're on the Nidus website, the blue menu bar has a selection called My Documents, and under that are topics related to other aspects of the planning process. So that's why it's important to let people know about the website and where they can find things, the people that you name in the documents. We have other resources on topics, related topics. On the website, click the Information tab to find information on the role of a representative, the role of a monitor, and the same for the enduring power of attorney, the role of an attorney. Very important that the people you name in these documents know their duties, their responsibilities, as well as their authorities and rights. And under the Get Help section, you'll find a page for videos as well as other resources. And don't forget to register. There are videos about aspects of the registry service, and it's about connecting the right information to the right people at the right time. And a screenshot of our website homepage shows the registry tab where you can find information, as well as a link in the right sidebar to the separate registry site. So what are the steps to action? First of all, you need to determine the path, the future path or need help today path. Click on the correct photo at the Nidus homepage, depending on the path and the situation. Read and discuss with others the information. Make the legal document, register the completed document, and make sure those that you named or appointed know about Nidus and the website so they can get information when they have to use the enduring power of attorney or the representation agreement section 7. Thank you for joining us. Please visit the website and watch other videos.